This meeting is being recorded.
Hi, everybody. Thanks for joining us today. I'm just going to give a few minutes for everyone to enter in, and then we'll get started. Hi, everybody. I'm going to give it just about one more minute, see how many people we get in and make sure we're not missing anyone, and then we'll get started. Thanks for joining us today. Hello, everybody. I'm going to give it just a few more seconds and then get going. Thanks for joining us. Okay, hello everybody. My name is Gina Couliard, and I am the Associate State Director for the Arizona Small Business Development Center Network. I'm so excited for our presentation today. I personally struggle in this area, and so I'm very excited to learn alongside you. Our topic today is Don't Burn Your Brand, and so welcome everybody. To get started, I'd like to tell you a little bit about our SBDC services. The SBDC stands for the Small Business Development Center. We are funded in part by the Small Business Administration. We offer one-on-one, no-fee, confidential business counseling services. We offer technical assistance in many areas, everything from business planning, access to capital, financial review, sales and marketing. Anything you can imagine, we have experts in most of these areas. We have a couple of specialty areas, which are international trade and export and technology and commercialization. We offer many no-cost or low-cost training programs. And one of the biggest features that we have, I believe, is our access to tools and resources, which we're going to talk about on the next slide. A few of the tools that the SBDC offers is LivePlan, which is a business planning software, Growth Wheel, which is a software tool that helps you make business decisions. We have a lot of benchmarking and research tools that include IBIS World, Vertical IQ, the NASBite, Trade and Password, Profit Sense, Profit Mastery, and of course, SBDC.net. These are all unbelievable tools that can help you make better decisions in your business as you move forward in your entrepreneurship. Access to these tools is made through your SBDC counselor, and we're going to talk about how you can get an SBDC counselor on these next slides. Before we do that, I would like to introduce Jason Lott, who is a managing attorney for Trademarks Customer Outreach, the U.S. Patent and Trademarks Organization, or office. Sorry, I did it wrong, Jason. He is going to be our presenter today. And he will be speaking about all things trademarks and patents, which I am very excited to learn. So how do you go and request assistance from the SBDC? So to request counseling, you would click on the link at the top of the page. You will then be assigned a business counselor. At this initial counseling session, you're going to identify your business goals and what area of assistance you need. And don't worry, that may be more than one. Follow-on sessions as needed are going to be set with your counselor so that they can help you achieve your business goals. Some of our clients we've had for years. Part of this process is going to be tracking your business goals and reporting your economic impact. So counseling is by appointment only and separated really by geography. So clients in Flagstaff would see a counselor in Coconino County, where clients in Tucson would see one in Pima. I just want to update you for some upcoming training that we have for our network. Very excited about this. It's how smart businesses can leverage credit cards. I know this would have been super helpful to me in my entrepreneurship journey. It's Wednesday, November 16th from 9 to 10. You can find a list of all of our trainings at the link listed on this slide. I want to thank you all for joining us today. A couple housekeeping items. This webinar is being recorded. At the end of this webinar, evaluation will be present for you guys to participate in. If you could do that, your feedback really guides us into making decisions as we move forward. And lastly, Esmeralda and I are going to be monitoring the chat. Jason's going to be stopping along the way to answer some of your questions. And at the end, we're going to open it up for a Q&A. So please send us your questions so that we can get them answered, because this session is for you. So thank you very much for joining us. And Jason, I am going to hand it over to you. Thank you.
Wonderful. Thank you very much, Gina. Appreciate it. I'm going to go ahead and share my screen here and we will jump right in. All right. So there we go. Okay. So hey there, everybody. My name is Jason Lott. I'm the managing attorney for Trademarks Customer Outreach at the USPTO. And really what that means is it is my job to teach you about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. Now, today, I'm going to be talking about a few more things than trademarks, but I want you to know trademarks is my specialty. It's my area of expertise. I'm pretty good in some of the other areas, but these other areas we're also going to talk about today are hopefully going to help you with the issues that you might have with your business. And today's focus is on intellectual property considerations for restaurants. So maybe you have your own restaurant, or maybe you're thinking about starting one, or maybe you have a food truck or a catering business, or whatever it happens to be. And for those of you who are on the line today who are not in the restaurant business, that's okay too, because of a lot of the concepts that we're going to talk about today are directly applicable to other industries as well. Some of them not so much, but a lot of the main concepts are. Anyway, you can apply it to whatever business you may happen to be in. So this is what today's going to look like. We have a lot of things to cover, but this is what it's going to look like. We're going to talk through what the major definitions of intellectual property are. We're going to dive into trademarks and also into trade dress in a pretty deep fashion. We're going to hit on a very light level copyrights, patents, and trade secrets. I want to talk to you about some resources that we have available. And of course, I do want to be answering your questions along the way. So if you don't mind though, you can pop your questions into the chat at any time. I'll probably take them every time we see one of these blue screens on your screen. And the reason I would like to sort of break it up that way is oftentimes folks have questions and they're right with me and they're asking a question that I'm going to get to on the very next slide. So to make sure we can move efficiently through the deck, if you don't mind, we'll take questions every time you see one of these blue screens. Okay. So first things first, let's dive into what in the world intellectual property happens to be and how that contrasts with other property that we think of. So when we think about property, we're typically thinking about property, right? We're thinking about real property, such as land or buildings, right? So if you have a restaurant, think about the land that your restaurant is on, or the structure itself. We also think about personal property, which would be the things that you might find in the restaurant, whether it's the furniture or the fixtures or the equipment that you have installed. The thing that we often don't think about is intellectual property, which are things that are sort of intangible. You can't hold on to them. You can't, sweep them. You can't hose them down. You can't mow them, right? These are products of the human mind, which are sort of hard to touch, right? But there are ways that you can protect them, even though they are technically considered to be intangible. And so let's think about the things that you might have at your restaurant, which you might not think about as being tangible property things, which you may or may not be able to protect and that may have lots of value to you. So what about the name of the restaurant? Maybe that's something that you would want to protect, or maybe the logo. or maybe the slogan that you use with your restaurant, or maybe there's a hashtag that has some significance for you that you're able to use. Or is there a menu item on your menu that is like a specific thing for you, or it has a very specific name which is unique to you? What about the layout of your restaurant? Or maybe there's a signature food dish that you have, and you're the only one that prepares this particular dish. What about a recipe? There are a lot of questions that come in about, hey, I want to protect this recipe. How can I do that? We're going to talk about whether or not you can protect a recipe. Right? We're going to talk about that here in a little bit. What about the way that you plate the food? Maybe it's a very specific way that you plate it. Or look, maybe you just, wrap the thing up in aluminum foil and put it on a styrofoam plate and shove it out the window. Hey, that works too, okay? Probably not something that's going to be protectable, but maybe there is something about the way that you serve the food that would be protectable. And what about collateral products? What about things like t-shirts and aprons and hot sauce and barbecue sauce and coffee and jams and jellies that you happen to sell at your restaurant when people are checking out? Hey man, I love that hot sauce so much. You guys got a bottle I could buy? Yeah, sure, here you go, right? So maybe those are things that you could also protect. What about the way that your menu is designed? Or what about various marketing materials? What about your website? Is that something you could protect? What about your customer list or a vendor list? Or what about the music that's being played in your restaurant? What's going to happen with that? Is that something you can protect, or are you going to get in trouble for using somebody else's music in your restaurant? So as you can see, there are a lot of things to think about when it comes to intellectual property and your restaurant or your food truck or catering business or whatever it happens to be. And these are all things that you can think about. Some of them are going to be protectable, some of them are not. So how do you protect the things that you can? Well, you protect them by securing legal rights in those things. And the way that you protect this sort of intangible sorts of stuff is through trademarks and trade dress. Trade dress is kind of a subset of trademarks, and also through copyrights, patents, and trade secrets. All right, so these are the 5 main things that we are going to be talking about today: trademarks, trade dress, copyrights, patents, and trade secrets. So let's take the big one first. All right, so this is my area of expertise. This is the thing that I'm most used to talking about, and that is trademarks. Now, what you're going to see on the screen is kind of the legal definition for what a trademark is. It provides protection for any word, slogan, symbol, design, or combination of these that does 2 things. That identifies the source of goods and services and distinguishes them from the goods and services of another party. All right, so okay, Jason, that's kind of, that's a legal definition here. That's kind of hard to parse. Why don't you give me an example of real life? Okay, so probably the easiest way to think about it is when you see the McDonald's golden arches, what do you think of? Hamburgers, right? What about Wendy's? Hamburgers. Burger King. Hamburgers, right? So every single time you see those logos or those brands, it automatically calls to mind a very particular set of goods and services. So those things are functioning as trademarks to indicate the source of the hamburgers or the restaurant services that they provide. Now, those trademarks are also distinguishing them from their competitors. So McDonald's, it's different than a Wendy's and it's different than a Burger King. Right? Same thing with any other restaurant, a KFC versus a Chick-fil-A or a Church's Chicken, or a Pizza Hut versus a Domino's versus a Donato's or whatever, So whatever that happens to be, we are using trademarks as consumers to say, oh yes, I want to get food from this restaurant because I know they provide this, delicious food at that restaurant. Same thing is going to be true for you and your small business or large business, whatever the case may be. You're going to be using a trademark to indicate in your customers' minds the source of your particular goods and services. Now, trade dress is something along the same lines as that. It is still indicating source, but the way that it's doing that is through the commercial look and feel of the product or the service that you provide. And I'm going to give you examples of all of those things here in just a couple of minutes. But again, the question is whether it is functioning to indicate the source of your goods and services. So when your customers experience it, they automatically know, oh yeah, that's right, I know who the provider of that is. I've been going to them for 20 years. So in terms of copyrights, what a copyright is, a copyright provides protection for an original artistic work. So think about things like songs or movies or books or paintings, sculptures, photographs, computer software code, things like that. So things that it's an idea in your head and then you affix it in a tangible medium, okay? So you write down a poem, you write down lyrics to a song that you're writing, you record something on your phone, you go into a booth and you record, a song in a recording studio, or you take a photo with your phone. All right, you are getting a copyright in the thing that you have just created. You have this idea and you've now affixed it into this tangible medium that somebody could either hold on to or see on a computer screen. You are automatically creating copyright rights in that artistic thing that you have just created. So you can see how that is different from a trademark, which is just indicating source. A copyright is protecting an original artistic work. Both of those things are different than a patent, which is going to be protection for an invention. Now that's on a very, very high level base level. Okay, so patents go much, much deeper than just an invention. All right, but it's an easy way to think about it in order to compare it to things like artistic works and brand name slogans and logos. So patents are going to be protection for an invention or a new way of doing something, and these are they're typically going to be more technical sorts of things. So maybe you've invented a new, solar panel, or maybe you've invented a new way to, extract moisture from the earth or something like that. I don't know. But something that is like this thing that you have invented a new way of doing something, or a new product or something like that. That's something that could potentially be protected through a patent. And that is, of course, also contrasted with a trade secret, which is really just something that has value because no one else knows how to do it except for you. All right, so think about things like the Coca-Cola formula, or the recipe for KFC chicken, or for Mrs. Fields cookies, or for WD-40, or for Listerine, for Twinkies, probably, right? Nobody really knows how you make those things, and those have value because nobody else knows how to do it. All right, so as you will see, that sort of concept, the idea of how to do something that no one else knows how to do, that can have value in the food service industry. All right, so those are the big things that we're going to be talking about today. Brand protection for brand names, protection for original artistic works, protection for inventions, and protection for secrets and ways of doing things that nobody else knows how to do. That's the overall view of what we're going to look at today. So before we dive in, Esme, Gina, anything come in the chat that we want to ask a question about right now?
Nothing. We haven't received anything in the chat yet.
Okay, cool. All right. Well, we'll dig into some trademark basics, and who knows, we might have a few questions as we go through here. Okay, so the easiest way to think about trademarks really is to think about the big sorts of types of trademarks, which are brand names and slogans and logos. When we, as consumers, typically think about trademarks, that's what we're thinking about. What's the brand name here? What's the slogan they might use? What's the logo that I'm going to look for on the packaging? And these are all different types of things that you can protect. So for brand names and slogans, the way that you protect them at our office is through something called a standard character format version of your trademark, which is protection for the wording itself. All right, not what it looks like, but for the wording itself. And I know that might sound very limiting, but it's actually incredibly expansive because it means over the life of the trademark registration, you can use your trademark in whatever typeface or style or size you want to. It's really, really broad. And so as you can see on your screen, it's written in kind of Times New Roman font there, but you see McDonald's, Happy Meal, I'm loving it. These are all registered trademarks of McDonald's, obviously. And you might wonder, why are they written in Times New Roman font there, Jason? Well, the answer is, that's how they registered with our office. So what they did was they submitted this standard character format version of their trademark. And they said, hey, USPTO, I only want protection for the wording itself. Here's the wording. And we said, okay, cool. And so that means over the life of these trademark registrations, McDonald's can put McDonald's in whatever typeface they want to. They could put Happy Meal in whatever typeface or size or style or color they want to. Same thing with any of their slogans, like I'm loving it, or, you know, to all beef patty, special sauce, lettuce, cheese, pickle, tomato, onion on a sesame seed bun, or whatever it is, right? So you can protect the wording itself and have this really broad, expansive protection for the wording. That's McDonald's has done it. Tons of other companies have done it. You can do it too. And it is a great way to get really broad scope of protection for the wording that comprises your brand name of your restaurant or something like that. So you can also protect hashtags. Didn't used to be the case that you could, but please be aware, if you want to get protection for a hashtag, you have to be using it as a trademark, not just as a way to search for things in social media, but you have to be using it as a trademark to indicate the source of your goods and services. You can see the examples there of hashtag fast foodie, hashtag steak worthy, and hashtag Viva La Rita. These were all registered trademarks. First one from Checkers, steak worthy was Logan's Roadhouse, and Bahama Breeze Island Grill was the, or Darden Restaurants really, for Viva La Rita. So is it possible to register a hashtag? Yes, but remember, you have to be using it to indicate the source of your goods and services, not just as like, you know, hashtag my restaurant or something like that on social media. You have to be using it as a trademark. All right, so those are the basic ones, okay? Your brand names and your slogans. This is a quick and easy way to get a really broad scope of protection. But you might be thinking, what about the stylization or design sorts of things? Those are important to me. I want people to be able to recognize those things. Okay, cool, that's fine too. You could apply to register what is known as a special form version of your trademark or trademarks. You can do that with our office, and you can have protection for the stylized or design elements that might be appearing in your trademarks. So if you take a look up here, you can see Ronald McDonald written in script. That's a sort of considered a stylized version. The McDonald's with the golden arches inside the square sort of thing, that's considered a composite trademark, where it's a combination of wording in a design, or just the design alone there of the golden arches. Now you might notice that these are in black and white. Have you ever seen these trademarks before in black and white? No, probably not, but that is how McDonald's registered them with us. And they did that for a very specific reason. Same thing that you can do as well, okay? By registering your trademark in black and white, you are essentially saying, hey, USPTO, I am not claiming any colors in my trademark. And we'll say, okay, fine. And what that means is, over the life of your trademark registration, you can use your trademark in whatever color you want to. We don't necessarily care, right? At various points, you're going to have to show us evidence of how you're using your trademark in interstate commerce. So the fact that you've registered in black and white, we're not going to care when we see your trademarks on that evidence that you submit. We don't care what color it's in. But if you did register your trademark in color, we would want to see your trademark appearing in that color on the evidence that you're going to be providing over years, right? So think about how your restaurant is probably going to change over years, over 5, 10, 20, 30 years. You might want to change up the colors. All right, so you might not want to be locked into your trademark only appearing in very specific colors, but you might want to give yourself some flexibility. Now, I am not allowed to give legal advice. Okay, so what I'm saying, not legal advice. However, what I can tell you is that a lot of times small business owners will do one of two things. If the wording is important to them, they would apply to register the wording alone in this standard character format. Gives them great flexibility and protection for the trademark. But if the stylization or design is important, they might submit another application for that stylized or design mark, but they do it in black and white. All right, so again, not legal advice. I'm just telling you what I've seen over the years. And it's a great way to potentially save yourself some money by giving yourself this broad scope of protection for various versions of your trademarks. All right, so let's kind of see how this works in real life. So as you can see on the left, these are McDonald's trademark registrations there for the wording itself, for the golden arches, and also for the arches with the words McDonald's. And you can see in the photograph on the right-hand side how these are used in real life. So we see the McDonald's trademark on the top of the restaurant there in their particular font. You'll notice the font or the typeface does not match how they registered with us. And that's fine. We don't care what typeface or size or color they put it in real life, because they've registered that standard character version with us. Same thing with the black and white golden arch. You can see it there appearing in yellow with like a little black background behind it in a couple places on the restaurant itself. Totally fine. That's okay. They don't, they could put that in pink if they wanted to, put it in green, put it in orange. We'd be like, that's fine, because you've registered it with us in black and white. Same thing true with the arches over the word McDonald's, and that sort of like rectangular shape at the bottom, up at the top of the sign. There, in real life, it appears in yellow, or I guess gold, and red and white and black. Does that match the black and white version they've registered with us? Nope, but we don't care because they've registered in black and white, and we don't care what color that they put it in real life. Okay, so this is how it plays out in real life. The value of registering the standard character version and also the black and white version of various trademarks. So let's take a look at how this would work if it's a menu item that you have on your menu. As you can see here, McDonald's has registered Big Mac, Quarter Pounder, and Double Quarter Pounder. I've circled them in red there on the menu itself. Again, what you see on the left, that's how they register with us. Does that match exactly how they put it on the menu? Well, the wording does, but not the typeface or the size or the well, color is the same, I guess, but we don't care sort of like what typeface or font it's used on the menu, because it's protection for the wording itself. Now, the great thing is you're not just limited to brand name, slogans, and logos. Pretty much anything can be a trademark so long as it indicates source. So here you can see McDonald's has registered the configuration or shape of their mascot, their Ronald McDonald, there on the left-hand side. Again, this was done a long time ago. It is kind of in black and white, although back in those days you had to sort of line your trademark for color. But we see it in real life what those colors actually are. They're the yellow and white and red and things like that. So if there is a mascot that you use with your trademark, hey, with your restaurant, cool. That might be something you could register with us if you wanted to. Again, you're not required to, you're never required to register your trademark with us, but you would have that option if, for example, the mascot that you use that prances around outside your restaurant, sure, if you wanted to protect that trademark, you could do that. Same thing with other configurations and shapes, like for example here, the Happy Meal. You can see on the left-hand side, a black and white version of their Happy Meal, but we see it in real life in red and yellow. That would be how they use it in real life. Same thing here with color. This is a pretty amazing thing. If there are particular colors that are associated with you and your restaurant, you could protect those as indicators of source. So you see on the left-hand side there, that's a French fry packet. It is sort of black and white, but it technically, because it's so old, was lined for color. The front was lined for red, and the back there was lined for yellow. And so you can see they have they're protecting this combination of red and white and yellow in their French fry package. So maybe there's something that you are doing that's kind of similar, and there are certain color combinations that you use for various packaging or something like that. Or maybe it's the awnings that you have on the outside of your restaurant. Here, McDonald's has registered the color yellow when used on awnings outside of their restaurants. So you can see on the left-hand side, the drawing that they submitted to us, they have indicated the color of yellow on those awnings. They have broken lines for the rest of the restaurant. It's called knotting something out, which is saying, hey, we're not claiming anything here. Nope, nope, nope. This is just kind of show you it goes on a building. But what they're really claiming there are those yellow awnings. And you can see on the right-hand side how those are actually used in real life. So you don't have to have any of this other stuff. Besides, you might just want to focus your protection on brand name or a slogan or a logo or something like that. But I want you to think creatively about the things that you use to help your customers identify you in the marketplace. All right, real quick check. Anything come in, Esme? Anything we want to talk about?
Yes, we actually received a question. So
Great.
how long after you create the logo or slogan do you need to make the trademark?
So if you've created the thing, there isn't necessarily a time that you need to wait. We can talk about various filing bases, and we'll talk about this here in a few minutes. But you are welcome to apply to register your trademark with us whenever you want to. Whether you've already started using your trademark or whether you haven't used it yet but have a bona fide intent to do so, doesn't matter. You're more than welcome to apply to register with us. Things will be different based upon whether you're using it already or not using it yet. But there isn't a specific time that you have to wait after creation before you file with us if you want to. It's a great question.
All right, thank you. We don't have any questions as of now.
Okay.
Thank you, Jason.
Sure, we might have some here in a few minutes because we're going to get a little bit deeper, okay? So into the way that your trademark rights are created. And so this is going to go exactly to the question that was asked. So trademark rights in the United States are based upon use. Right? That's not true in other countries. There are some countries where it's not based on use. Whoever's the first one to file has trademark rights. That's not how we do things in the US. Here, your trademark rights are based upon the fact that you are using something as your trademark. Now, there are multiple ways that trademark rights are created, but I want to focus on the two main ways that they're created, and that is through common law and through federal registration. I'm going to talk you through both of these things. So common law trademark rights are sort of the quickest and the easiest. And these are rights that you might already have if you've already started up your restaurant and you're already using your trademark, because these rights are created as soon as you begin to use something as your trademark. Now, these rights are created under state law. And the problem with common law rights is that they're going to be limited to the geographic area in which you are operating. So if you're only operating in Maricopa County, then that's where your rights are kind of going to be. Now, obviously, the internet kind of changes that, because if you're online and you're selling stuff to people all over the place, or you're advertising to out-of-state visitors as they're crossing Arizona, sure, okay. So maybe the geographic limitation isn't as much in play. But remember, these rights are created state by state. So it's going to be pretty limited to the area in which you're operating. And there's nothing that you really need to do in order to secure these rights except for use something as your trademark, okay? Because the rights are created based upon your use of the trademark. What you can do is put a little TM next to your trademark, or a little SM next to your trademark. TM stands for trademark. SM stands for service mark. You don't really have to worry about the distinction between the two of them, because TM or trademark kind of covers both things. So sometimes you'll see an SM, but it's pretty rare. Most of the time, you're just going to see a TM. And you don't have to ask anybody if you can put a TM next to your trademark. Right now, in this moment, you could pop open whatever it is you have on your computer where you keep your trademark, and you can put a little TM next to it, and that's fine, and start using that TM next to your trademark. Okay, there's no particular typeface you have to use, or a size, or a placement. Oftentimes, people put the TM to the right of their trademark in either a superscript or a subscript. And the great thing about doing this is you are putting the public on notice, hey, I am claiming this, I am using this as a trademark, right? Which is going to help if you ever have to if you get hauled into court and say, like, are you really using this as a trademark? You can say, yes, I am. And I've been using it since, I don't know, October of 2022. Look, you can see there's a little TM next to my trademark. I am clearly claiming this as a trademark. I'm putting people on notice. Okay, so you can do that if you want to. The one thing you cannot do, however, is use the R in the circle symbol, because that is reserved for trademarks that have registered with our office. But you are more than welcome to put a TM next to your trademark, because that's going to help put people on notice that you are claiming it as your trademark. And that's fine, okay? You could go your entire business life just relying upon these common law trademark rights. And that might be fine, especially if you just want to have a small business, keep it in one area. But what happens if you want to expand your business? You want to expand it beyond Arizona and across all of the Southwest. And then you want it to become a nationwide brand. And maybe it becomes an international brand, right? Where you're selling all over the place, right? Well, you're going to want to have protection for your trademark as you expand in a whole lot of other places. So you could, if you wanted to, rely on common law trademark rights, but it's going to be kind of difficult because you're going to have to sue people in state court all around the United States and things like that. Instead, what you could do, however, is register your trademark with us, with the federal government. And that's going to create a whole bunch of different rights for you. And these rights are created as soon as you register with us. It creates a legal presumption that you are the owner of the trademark and that you have the right to use it throughout the United States and its territories. So no longer are you limited to just like trying to oh, I got to protect myself over here and protect myself over here. Now you can say, hey, judge, check this out. I have a trademark registration here, which is this legal presumption that I own the trademark and I have the right to use it throughout the United States and its territories. And it's pretty amazing. You're also putting the public on constructive notice that you are the owner of the trademark, and you can bring a legal action concerning your trademark in federal court. So no longer do you have to go to all these different state courts in order to sue somebody. Instead, you can go to the federal courthouse nearest you and say, hey, judge, I'm suing this guy all the way over in New York because he's infringing on my trademark rights. And that means that that guy in New York will have to come to you to defend instead of you going to him in order to sue. Pretty great benefit. You can also record your registration with U.S. Customs and Border Protection. So if whatever reason your restaurant is encountering counterfeit goods coming in the country, I don't know, maybe you have an amazing hot sauce or amazing barbecue sauce, and somebody in other parts of the world are creating counterfeit versions and sending them into the country. Well, you can record your federal trademark registration with CBP, and their agents will work to stop those counterfeit goods from entering the country at our ports and at our borders. You can also use your federal application or registration as a basis for filing in other countries. So remember, trademark rights are going to be country-based. There is no international trademark, no worldwide trademark protection. Okay, so there's no one place where you can go register and then be protected all around planet Earth. That doesn't exist. Okay, if you want protection in a country, you have to file there in order to get protection in that country. So that can obviously be pretty expensive, be pretty time consuming. And so we have agreements with other countries around the world we have this protocol in place where you can use your filing in the United States in order to serve as a basis to extend protection into other countries. Now you're still gonna have to have applications there and make sure you get registrations there, and it's gonna cost money and all that sort of stuff. But this protocol is there for you to use in order for you to have an easier way to extend your protection into other countries. So again, it's going to be up to you as the business owner to decide, okay, I do want to make sure I have protection in Mexico, and I also want it in Canada. I probably don't need it in Asia yet, but I know that I'm going to be moving into parts of Central and South America soon, so I want to have protection in countries along it, right? So you can make those decisions about where you want to try and extend your protection, because you're going to want protection before you move into that particular market. Now, once you've registered with us, you no longer need to use that TM or that SM, and instead you can replace it with the little R in the circle symbol. And again, there's no necessarily rules on how you use the R in a circle. Most of the time, you'll see it in a small superscript or a subscript to the right of the trademark. If you can see in the bottom right-hand corner of your screen of my slides, you can see to the right of the USPTO logo in the bottom right-hand corner is a little R in the circle. And that's because we, as a federal agency, have registered our trademark. So when you see the USPTO logo, you know it's good information coming from us. Okay, so any questions about that happen to come in?
No, actually, we have not received any questions.
All right, good deal. All right, we'll move right along. Okay, so let's say that you say, okay, Jason, I got it. I understand what a trademark is. I understand why I might want to register with your office. What are some things that I need to think about before registration? And so that's what we're going to talk about here. We're going to talk about the things you want to think about before you apply to register. So just a reminder, it is our mission as the USPTO to register trademarks. That is what we are here to do. That is what we want to do. However, not every trademark is registrable, right? There is an examination process that every single trademark goes through. So you have your trademark, you apply to register it with us. It gets assigned to a trademark examining attorney, and which is the job that I had when I first started at the USPTO many, many years ago. And that examining attorney is going to look at your application and decide, yes, this one is eligible for registration. It can move on. Unfortunately, this one is not. It has to be refused registration. Here is why. And you can have a conversation about that and try to overcome it. So please be aware, it's not a simple thing of like, look, I paid money. Where's my certificate? That's not how it works, okay? Because of this use-based requirement, there are all sorts of other requirements that are in place. And so there's this examination that happens. The other thing that I want you to think about is that even if your trademark does registrable, please be aware it might not be enforceable. I'm just going to give you a second to think about that because that's kind of wild, right? You're like, Jason, I just spent all of this time and effort to register my trademark. You're telling me that I cannot enforce it? Maybe. And that's because of common law trademark rights. Because remember, trademark rights in the United States are based upon use. And there is no requirement that you register your trademark with us. You could go your entire life based upon your common law trademark rights. And how that plays out here is, let's say that you apply to register a trademark, the examining attorney looks in our database, doesn't find any federal reason why your trademark should be refused registration and moves on to registration. However, there's somebody out there that has never relied upon a federal registration, has just been relying on common law trademark rights and says, whoa, 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 whoa. I have been using this trademark under common law since 1919, and I have these really strong rights, and so therefore I am going to file to cancel your registration. Now, does that happen very often? No, right? But you want to be aware of those potential dangers so you can avoid that situation. So the two things that I'm going to talk about right now are going to hopefully help you make sure that your trademark is both federally registrable and legally protectable. And those two main concepts are likelihood of confusion and the strength of the trademark. And these two things right here are the two main reasons why trademarks are refused registration at our office. All right, so the examining attorney is looking at your application and says, uh-oh, there is a likelihood of confusion here. Your trademark must be refused. Or, uh-oh, this trademark is descriptive. It must be refused. So let me walk you through both of these things, okay? And then, of course, I will answer questions because there probably are going to be some after this section, okay? So likelihood of confusion really boils down to a test of whether your trademark is confusingly similar to one that the examining attorney finds in the database. And so the examining attorney is going to be looking at your application and looking in our database. And if she finds something, she's going to say, let's see, are these trademarks confusingly similar? Do the trademarks look alike? Do they sound alike? Do they have a similar meaning? Or maybe a similar commercial impression? You don't have to have all four of those things be true. Just having one of those things be true is enough. And so the examining attorney is doing this two-part analysis. Are these trademarks similar? Yes, they are. So let me move on to the second part of the test, which is asking the question of whether the goods and services are related. And really what that means is, does one company typically make both types of goods? Or does one company typically provide both types of services? And if, as consumers, we're not used to one company doing both things, or the examining attorney can't find evidence that one company is typically doing both of these things, they're considered unrelated. And so therefore there would be no likelihood of confusion, right? So think about it this way. Let's say that you wanted to register McDonald's for chicken sandwiches, and the examining attorney finds McDonald's for hamburgers. Is that going to be a problem? Yeah, right? Because the trademarks are confusingly similar, and chicken sandwiches are going to be considered to be related to hamburgers, right? So a refusal in that case. But keep in mind that the other thing could be true. Let's say you have two different places. One of them provides hamburgers, the other provides hamburgers, but one of them is called McDonald's and one of them is called Wendy's. Is there a likelihood of confusion there? No, consumers are not going to be confused, even though both restaurants are serving burgers, because they're using the McDonald's trademark to differentiate and the Wendy's trademark to differentiate. Okay, so that's why you will often find, even within one particular restaurant industry, where lots of people are serving Mexican food or Thai food or Italian food or standard American fare, whatever it is, right? Then they can all sort of coexist because the trademarks themselves are different enough that they're not going to confuse consumers as to source. So before you apply to register with us, we always suggest that you do a search of our database using the trademark electronic search system called TESS, T-E-S-S. And you're going to be looking in the exact same database as the examining attorney. And we always recommend that because if the examining attorney can find it in there, you can too. And you can look for it and maybe find it before you file. So you can save yourself all sorts of time and money and effort if it's just going to be like, oh man, I wanted to register Jason's as my brand name for my restaurant, but I looked in here and there's already a Jason's that provides restaurant services. Maybe it's time for me to think about a different trademark or changing my trademark in some way to avoid causing confusion. The other thing that we recommend is that you look online. You're going to want to be looking for those common law users that are already out there. So just do a search on Google or Bing or Yahoo or DuckDuckGo or whatever search engine it is that you use. And you're going to look to see, is anyone else out there using a same or similar trademark for related goods and services? If all that feels like too much, though, and you don't want to do that, say, well, we also recommend you might want to think about hiring a private trademark attorney to assist you. And yes, those can be expensive, and I can talk to you about some free and reduced price legal services that are available. But the reason I point it out is because an attorney can do a really great, comprehensive, full-on clearance search for you. That's what you're doing here. You're trying to clear the area around your trademark to make sure there's nobody else that's going to be conflicting with yours. And the private trademark attorney can look in all sorts of different databases and resources to try and determine whether or not there's going to be a problem when you apply to register with us. All right, so that's one thing. That's the likelihood of confusion, which can manifest as a likelihood of confusion refusal. The other thing that I want to talk about is the strength of your trademark. So there is something called the descriptiveness spectrum, but I like to think about it as a temperature gauge that goes weak to strong or cold to hot. You want your trademark to be in the hot range. You want it to be in that fanciful or arbitrary or suggestive range. You do not want it to be in the descriptive or generic range, in the weak or cold parts. Okay, so I'm going to show you some examples of all of these things. And I want you to think about your trademark and where it falls on this spectrum or on this temperature gauge. So the hot trademarks, would be something like a fanciful trademark, which is a made-up word. Okay, it has no meaning necessarily in English or in any other language. And so, we've heard, obviously we know, as consumers know, Starbucks now, and it was a character from Moby Dick, also from Battlestar Galactica, right? But Starbucks doesn't necessarily have any meaning in English or in any other language. So it is fanciful or coined. That's incredibly strong as a trademark. So think about your trademark for your restaurant or your food truck or whatever it is that you provide. Is it made up? Is it fanciful? If so, great. Those are inherently distinctive. There's a broad scope of protection that you have for those. Same thing with arbitrary trademarks. These are words that have meaning in English or in another language, but that meaning has no relationship whatsoever to the underlying good or service that's provided there. So here, sonic is a word having to do with sound. It has a meaning in English, but that has no relationship whatsoever to restaurants, right? So here it is incredibly strong. It is inherently distinctive. And so think about your trademark and whether it is arbitrary for your restaurant services or food truck or catering services or whatever it is that you provide. Is it arbitrary when used with those? So the more sort of like common examples outside the restaurant industry for fanciful would be things like Kodak or Exxon or Kleenex or Pepsi. And for arbitrary trademarks, it would be things like Apple or BlackBerry or The Gap, right? So those trademarks, when used with their underlying services, are either fanciful or they're arbitrary. Really, really strong. Okay, these are great trademarks because they're so strong, you're less likely to run into a likelihood of confusion refusal because chances are other people aren't going to be using something similar. Now, you might run into more likelihood of confusion issues as you come down our temperature gauge and we get to things like suggestive trademarks. So here, the dough roller is suggesting something about the sorts of goods that you might eat when you go to this particular restaurant, but it's not exactly describing a restaurant. Okay, so it suggests something about maybe what is done in the kitchen, and they roll out a bunch of dough for pizza and for baked goods. But it doesn't necessarily directly describe a restaurant. So again, think about your trademark. Does it suggest something about the goods that you provide in your restaurant, or not? Okay. Suggestive trademarks, also very good, also inherently distinctive. What you want to avoid, though, as we get into these colder trademarks, are things like descriptive trademarks, which describe something about the underlying good or service. Or in this case, California Pizza Kitchen is geographically descriptive of a pizza kitchen in California. Okay, so that can be a problem. So it can also be refused registration at our office on our principal register, which is the register that you want to be on. There's another register called the supplemental register, which kind of exists for trademarks that could someday really function as trademarks, but they're not there yet. You want to be on the principal register. And descriptive trademarks are going to be refused registration on the principal register unless you can show that these trademarks have acquired distinctiveness in the minds of consumers, which is going to be the case here for California Pizza Kitchen. They were able to say, okay, maybe it is geographically descriptive of our original restaurant, being in California and serving pizza, right? But now consumers, when they see California Pizza Kitchen, they see it as a trademark and they automatically think of us. So think about your trademark. Does it describe your the good or the service that you provide? Is it geographically descriptive of them? If so, that might be a problem when you're applying to register, and it could get refused unless you can prove that it has acquired distinctiveness in the minds of your consumers. Now, what I would very much like for you to avoid is generic terms, which would be the name of the thing itself, right? You would never be able to register cafe as a branding for restaurant services because we automatically know what it is. It's a cafe, okay? It's not indicating the source of goods and services. It's just telling you what the goods and services are. So generic, never going to be registrable when it describes what the thing is, or is the generic name for the thing, or the generic name for the service. Another thing that you do want to be aware of with regard to trademarks is, are you inadvertently making some sort of advertising claim in whatever it is that you're trying to provide? And can that claim be legally substantiated? So apparently at one point, Smashburger had a burger called the Triple Double. And it was held to be literally false and was false advertising because the Triple Double seemed to advertise a sandwich that was double the beef, but instead it was actually just double the layers. And each of the patties that they used were half the weight of the classic Smashburger. So it wasn't more meat that you were getting on the burger, it was just rearranged and put into a different way. So in that case, that was held to be false advertising. So be very careful of your trademarks and make sure you're not, advertising something that you cannot support. All right, so I very quickly want to hit a registration, just a really quick overview, okay? Because this can get pretty complex, but I want you to be aware of the main points. So as you can see on your screen, this is kind of what it looks like. If you decide, yes, Jason, I would like to apply to register my trademark with your office. So this is how it works. You would apply, that's the green arrow there. Then it would come to us, you would submit it to us, we would examine, that's the yellow arrow there. And then if everything goes well, it moves on to that purple phase called publication. And then it moves on, hopefully, to the blue arrow there with registration. That's very basic, right? It kind of makes sense. You apply, we examine, there's this weird sort of publication phase, and then hopefully moves on to registration. Now, it's obviously a bit more complex. There's going to be back and forth between you and the examining attorney assigned to your case, and it's not immediate. It does take time to work through this process, but that's kind of how it boils down. So if you decide to apply, you'll be filing electronically through our trademark electronic application system called TEAS, T-E-A-S. There are two filing options called TS Plus and TS Standard. I'll talk about the difference in just a second. But just be aware of what needs to go into your application. You have to tell us what your trademark is. Okay. And again, it's going to be up to you as the business owner to make that determination. Do you want to register that standard character format version to protect the wording alone? Or do you want to protect the stylized or design version, probably in black and white? And you just have to choose that in your form and say, this is the version that I want to apply to register with you. And we'll say, okay. You also have to tell us what the goods and services are that you use with your trademark. Because remember, trademarks are always, always, always tied to specific goods and services. You have to tell us what those things are. Oh, I'm registering Jason's for restaurant services. I'm registering Jason's for barbecue sauce, for hot sauce, whatever the case is. Okay, you have to tell us what those things are. You also have to tell us what your filing basis is. And this is going to go back to the question that was asked earlier about, is there a sort of waiting period? And the answer is no, there's not, but you have to tell us the basis, the legal reason that you can apply to register. Is it, I am already using my trademark across state lines? Or is it, I'm not using my trademark yet across state lines, but I have a bona fide intent to do so within the next 3 to 4 years? Either one of those is fine, but just be aware for this one, for the bona fide intent, even though it's easier to file right away, there are more things you're going to have to file later on in the process, and you're going to have to pay a couple of, at least one filing fee later on in the process. But again, it's going to be up to you as the business owner to decide. A lot of times people ask if they should wait. And again, I can't answer whether you should wait to file until you're using your trademark or not. What I can say is, though, there are lots of people who apply using the bona fide intent basis because they know they're not there yet, but they're going to be, and they want to be first in line. They want to stop their competitors from being able to jump in and say, oh, no, 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 I was going to register that trademark. No, 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 it's mine. And so by you being first, you're going to block those other guys, those potential competitors, from registering a trademark that is likely to cause confusion with yours. So the other things that you'll need to include, your contact information, so we can get a hold of you. And of course, there is a filing fee. For those of you wondering how much it costs, the standard fee is $350 per international class. I'll explain international class in a second. But if you are willing to use our more streamlined, efficient form, the TS Plus version of the form, you can save yourself $100 per international class. And the reason that we have that lower filing fee for TS Plus is because we are trying to incentivize you to use it. We want you to use and file TS Plus. And that's because you are front loading your application with everything you need to include. And that makes it easier and more efficient for the examining attorney. And it also means your trademark will move more quickly through the system. So we would love for you to file TS Plus. And with regard to international class, you might remember I said there's no international trademark. That is true. What the international class actually means is that we, the United States, have agreed with countries around the world that goods and services will be divided up into 45 different classes, or categories is one way to think about it. Don't worry about it. Okay, don't worry about classification and things like that. The only place that classification matters is with regard to figuring out your filing fee. Because your filing fee is not based upon the number of goods or services that you list with us. Instead, it's based upon the number of classes that happen to appear based upon the goods and services that you include. All right, so if clothing is in one class and hot sauce is in another class, your filing fee is going to be $250 times 2, because clothing is in one class, hot sauce is in another. And again, we don't care if you have t-shirts, hats, jackets, pants in one international class, class 25, filing fee is still $250. And same thing with, well, I have hot sauce and I have barbecue sauce, and in this other one. Okay, fine, it's still going to be $250 for this class. It's up to you which things to identify in your application, which things you decide, yes, I'm using it with these things. That's going to cost me $500 instead of $250. Let me just not register for these things over here. I'm just going to focus on my hot sauce and my barbecue sauce. That's okay. You can do that. So your filing fee is going to be based upon your choice of how many goods or services you list that are in various international classes. So we've already talked about a couple reasons why your trademark could be refused registration, including geographic descriptiveness. We don't have time to go through everything today, but just be aware that there are other reasons your trademark could be refused. If your specimen doesn't support use for the items that you list, you're using your trademark ornamentally, things of that sort. So just be aware there are other reasons why your trademark could be refused. And also be aware that it's going to be up to you to enforce your trademark rights. So we're not an enforcement agency. There is no trademark police. It is going to be up to you and your attorney, if you work with one, to send that cease and desist letter or sue someone if you need to. It's also going to be up to you to file your post-registration documents with us. So trademark rights and registrations can last forever, so long as you continue to use your trademark in interstate commerce and you file your documents with us. Also want you to be aware that your information does become public record. So it's a requirement. We have to make it available so other people can contact you if they need to. This is your application information. But just be aware, because that information becomes public, there are companies that scrape our database and then they start sending you solicitations. They're trying to either have you buy their services. Sometimes they're legitimate. Oftentimes they are not legitimate. Oftentimes the people contacting you are trying to scam you, and they're trying to trick you into paying money that you do not need to pay and get services that you do not need. And oftentimes they are pretending to be the USPTO, which is one of the reasons that we needed to register our logo, our trademark, in order to protect ourselves from these folks who were pretending to be us. Okay, so just want you to be aware that those folks are out there. You'll probably start getting stuff in the mail from these people, and they are doing they do a pretty convincing job sometimes of trying to convince people to pay money that they do not need to pay. Please be aware. All right, before I jump into trade dress, any questions about the previous things that I can clean up?
Yes, we do have two questions. All right. So the first one is Coastal Cocktails have the term hot chocolate bombs trademarked, and Heritage Distilling have cocoa bombs trademarked. Wouldn't that fall under confusing like meanings?
That's a great question. So I have to be very careful here, okay? Because I'm not allowed to give legal advice. I am also not allowed to comment on the registrability of trademarks, specifically trademarks determinations that have already been made. So I cannot directly answer your question about those things and whether or not there would be a likelihood of confusion. If they are both registered, then it sounds like the examining attorneys in those cases determined there would not be a likelihood of confusion between those two things. And again, I can't speak to exactly why that would be, and certainly cannot without seeing them in front of me. There might be other reasons that might be in there. But what you're identifying is exactly the sort of thing that needs to be identified. It is about trying to understand what are the differences, if any, between these trademarks. Are they confusingly similar? And also for the underlying good or service. So it sounds like you are already doing the analysis, and I love it. Okay, that's exactly what you need to be doing and be thinking about your trademark and whether it's going to cause confusion with other people. So thank you for asking the question. Unfortunately, it's not something I can give you a specific answer on, but you have exactly nailed the whole point of likelihood of confusion.
Jason, can I interject here?
Sure.
So say that situation occurs and you are the person with the first one, the cocoa bombs, and then someone files for the second one. Can you contest that?
There are sort of different ways of going about it. Yes, you can file, in some cases, a letter of protest and sort of make information available to the examining attorney. You would not necessarily be involved in the process of the examination, but what happens during the examination is the examining attorney is probably going to say, again, not speaking to this specific one, but if there is a likelihood of confusion, the examining attorney is going to go ahead and make the refusal anyway. So it wouldn't be anything you as the brand owner would need to do. If, however, it goes through, the examining attorney determines there's no likelihood of confusion here, the new trademark is going to move on towards the publication phase. And I didn't talk about it too much, but it's that weird sort of purple phase. And what happens there is a trademark is published for opposition. And that means it begins this 30-day opposition period in which any member of the public who has reason to can oppose registration of the trademark. So at that point, you as the brand owner could file for an opposition proceeding before the Trademark Trial and Appeal Board and say, whoa, 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 whoa. I am opposing this. They should not be able to register this, and here is why. And so you could oppose publication and registration at that point. If you happen to miss that and it goes all the way through and actually registers and you don't realize it until afterwards, oh, wow, how did this get registered? If it's within the first 5 years after registration, you can then file for a cancellation proceeding with the Trademark Trial and Appeal Board, and you can file to try and get that registration canceled. So there are different times throughout the process when you can sort of raise a flag and say, oh, this should not be happening here. And it's a sort of thing that you need to do because you need to be able to show, should it come down to it later, that you have been actively trying to enforce your trademark rights. So that's an excellent question, Tina. Thanks.
Thank you. All right, so the next question is, if someone is using a logo or slogan as a common law trademark, but someone else files for the trademark, who gets to use the logo or slogan?
That's a great question. Okay, so remember, the person who's using it first has the stronger trademark rights. So you might have been using it for 20 years, okay? And so technically you would have the stronger rights. You see that someone else is applying to register it. You could take advantage of these opportunities and say, whoa, you cannot register that. I'm the one who should have those trademark rights, okay? So it could be a situation where you are able to stop registration of the other trademark based upon your stronger common law trademark rights. Or it could be a situation where it ends up before the Trademark Trial and Appeal Board and they say, well, okay, you have stronger rights in the Southwest, but you didn't necessarily have any rights anywhere else in the country. So this other group, we can sort of carve out, it doesn't happen very often, but something called concurrent use, where you would be able to use it in one part of the country and then somebody else would be able to use it in a different part of the country. So technically, it's going to be the person who's been using it longer, but be aware, remember, there's the problem with common law trademark rights is that they are territorial. They are sort of like regional to the area in which you are operating. So if you want to have protection across the United States, the best way to do it is through federal registration. You can avoid situations like that, where you've just been relying on your common law rights and then somebody else comes along, a junior user, and tries to insert themselves, and it could potentially create confusion, right? Especially if you have people who know you and come in from other parts of the country, they're gonna be like, oh wow, cool, you now have an outpost in New York, great. No, I don't. Okay, so that's the other guy. So could be a problem, which is why federal registration is such a great benefit for you, because you're automatically going to get protection across the country. Good question.
All right, thank you, Jason.
All right.
Those are the questions we have right now.
Okay, cool. So let's jump in and talk about trade dress, which is kind of a subset of trademarks. It's still all about the same thing, about identifying the source of goods and services. So the most common ones, at least in the restaurant industry, are going to be either the exterior or the interior of the restaurant. It's really talking about what's the look and feel of your product or the look and feel of your service. It could be something like the signage that's outside your restaurant or brick and mortar. If you don't have a restaurant, you have some sort of other business. It could be the layout, the floor plan, or even the decor of the place inside your restaurant or inside your store. And so by being able to protect your trade dress, it's going to hopefully prevent copycats from being like, oh, wow, what a cool layout. I'm going to do the exact same thing, right? And then it's going to confuse consumers when they encounter your different restaurants or businesses as they're out and about in the world. So trade dress has its own sorts of, quirks, right? But it is registrable if it is non-functional. So it can't be a functional thing like, oh, well, this, sidewalk, I'm going to register a sidewalk because no, right? That's going to be functional, probably, not going to be able to register that. And it also has to be distinctive. There has to be something about it. It's unusual. It's memorable. It pops in somebody's mind. Oh yeah, that's right. Every time I see that, I immediately think of so-and-so, right? So trade dress can be registrable if it is non-functional and if it is distinctive. Probably one of the most famous examples of protected trade dress is the contour shape of a Coca-Cola bottle. It is non-functional because the sort of like contour ribbing sort of shape doesn't necessarily affect the functionality of the bottle. And it is also distinctive because when it came out in 1911 or 1916, sometime in the early 1910s. It was distinctive because nobody else had a bottle that was in that shape. And obviously now they've been using it for over 100 years. And when you see a Coca-Cola bottle, you know it's a Coca-Cola bottle, right? So same thing is going to be true for whatever it is that you're providing. Let me give you an example here of the original McDonald's hamburger stand. You can see on the left-hand side, that's the sort of trade dress. That's what the layout of the exterior of the building looks like. And then you can see it in real world, what it actually looks like in real life on the right-hand side. Same thing is true here with Mendocino Farms. They're blue and white cow. If you've ever been to one of these restaurants, you'll see a blue and white cow at various places throughout the different restaurants. And it's a way for them to say, hey, if you see the blue and white cow, you know it's us. If you've ever been into a what? An In-N-Out burger, then you obviously will recognize this. As you can see, they have registered the trade dress of the layout of the restaurant. You can see on the left-hand side there, the red and white tile. You can see the white stools. You can see the red booths, the white table. You can see the things that are knotted out through broken lines. They're not necessarily claiming any rights in the doorway or a window or those pendant lights that are hanging down, but the use of red chairs, with white tables and things like that. So when you walk into an In-N-Out burger, you're aware that you're in an In-N-Out burger. Same thing would be true with Chipotle, okay? If you've ever been to inside a Chipotle, you know you're inside a Chipotle. And you can tell based upon the layout and the trade dress and like their chairs and the use of the metal grating, and all those sorts of things, you know you're inside a Chipotle. So again, if that applies to you, great. It's potentially something that you could apply to register with us. So when people walk into your restaurant or into your store, then they automatically know that it is you. And if they've walked in, you could blindfold a person, drop them down, and like, oh yeah, I know exactly where I am. Okay. So plating for food that you might serve at your restaurant, possibly protectable as trade dress, but it has to have a pretty good reputation in order to indicate the source of the particular dish. So maybe something like this. This is by Chef Ackett's at Chicago restaurant Alinea. So this is actually a salad that is kind of, quote, growing in the mud. I'm actually not sure if the mud is edible or not. It would be kind of cool if it was. But this way of sort of plating something could be. Look, a salad is always served this way at our restaurant. Maybe something like that could be. Or this dish here, this is an egg dish from Andoni Oduriz of Mugaritz restaurant in Spain. That yellow block there is actually an egg. So this is a particular way of plating the food. In this super cool example here, this is by Chef Omaro Cantu of the restaurant Moto in Chicago. This is called the Cuban Missile Crisis. And this is actually a Cuban pork sandwich. Be kind of hard to think about, but it is actually bread, pork, and pickles, which were flattened, rolled, fried, and wrapped in a collard green. And the lit end where the ash is, the lit end of the thing is that's actually red pepper puree, and the ash in the thing is actually toasted sesame seeds and spices. So again, I'm not saying that necessarily this is something that is protectable as trade dress. It could be. So again, if there is a way that you were always serving your food, some very particular thing that the public, once they know, oh, it's always on a blah, 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 or it's always shaped this way, I know it must be a so-and-so. That is potentially something that could be protectable as trade dress because it is indicating the source of your goods and services. Any questions about any of those things?
No questions right now.
Okay, cool. Let's hop into copyrights. So copyrights, again, you might remember, trademarks protect brand name, slogans, logos. Copyrights protect original artistic works. Now, trademarks can last forever so long as you continue to use them across state lines and file your documents with us. Copyrights are different. Copyrights expire after 70 years after the death of the author or up to 120 years after creation if it's a business. So these actually do expire after some time. So people often ask, hey, can I protect my recipe from the dishes that I'm using in my restaurant or even that you're cooking at home? Technically, probably not. Okay, these are not going to be protectable by copyright, and it's subject matter that is specifically excluded from copyright protection. And the reason for that is because it is merely a statement of fact. It is just a listing of ingredients. It is therefore functional, and it describes this procedure or process or system for making a dish. And it doesn't have any of the amount, that sort of like creative expression that goes along with it. Now, could you get copyright protection for a cookbook? Maybe, right? If there's artistic stuff that you're doing inside the cookbook, you're telling stories about your childhood, my grandmother taught me how to cook, or whatever, like those sorts of things. Like there are ways that you could get protection for the stuff that's inside the cookbook, but it's not going to be protection for the recipe itself. So look, if you publish a recipe in your cookbook, you can't be like, whoa, you're not supposed to be making that. That's my recipe. No, you have published it. It is out there. It is a listing of ingredients and a way of putting something together. You don't have protection for that. Okay, if you want to keep that protected, well, we'll talk about trade secrets here in a few minutes. All right. So please be aware, recipes are probably not going to be protectable by copyright unless there is some artistic way that you are expressing this recipe. But then again, the protection is only going to be for the expressive way that you talk about the recipe, not for the listing of ingredients or the ways that you put them together. So the way your menu looks, hey, maybe that's something you could protect via copyright, because there's an artistic way that you have designed the layout of your menu, the different things that you have put on there. Yeah, that could be something that's protectable through copyright. But just be aware that the sort of names, titles of things and stuff that you might have on your menu for various menu items, those are not copyrightable. They are potentially protectable by a trademark, if we think about our Big Mac Quarter Pounder examples. So again, not copyright protection for the name of a dish, but potentially that could be something that you protect through as a brand name of your particular dish. Also be aware that the typical layout of a menu is something like appetizers, mains, desserts, right? That sort of stuff. Like that layout probably not going to be protectable, because that's the way that everybody designs a menu, because that's the way that we're used to reading menus. We start over here and work our way across. Your website, yes, that is protectable through copyright because you are artistically expressing yourself in the design of your website. So if you want to protect your website design from getting ripped off by other folks who have a similar restaurant to yours, then you could protect you already have your copyright protections are created upon creation of the thing itself. But if you want to register your copyright with the U.S. Copyright Office, then you can do that to get some additional protection. So just be aware, if you see something on the internet, always remember, it does not mean it is free. It does not mean it is public domain. If something is on the internet, chances are it still has copyright protection underlying it. And the same thing would be true of your website. Same thing with if you've built something on social media, your page or whatever, something like that, then there could be copyright protections that you have in the design of the page that you have built. So plating, potentially something that's protectable under copyright, not really sure. So I wouldn't necessarily rely upon this, because if the food is any good, it's probably not going to be affixed in this medium for very long, but that salad's going to get ripped apart and someone's going to take a huge bite out of that Cuban sandwich cigar over there. Okay, so plating, probably not so much. Please be aware that the architecture of your restaurant or your business is protectable by copyright. But remember that the design of the building, those rights belong with the original designer or that architect. So if you want the rights to the exterior layout or whatever, or the interior sorts of thing of your restaurant or your store, you're going to have to make sure that you have those rights assigned to you by the designer or by the architect. And that's incredibly important. So that's going to be in your contract with the architect. Oh yeah, please build me a thing that looks like a gigantic, castle from, whatever, a medieval castle. Okay. So they can do that, but make sure that you are getting those rights assigned to you, because you want exclusivity. Because what happens if you have one restaurant, very successful, and then you want to build another one? Well, you'd have to go back to the designer and say, hey, I would now like for you to help me build this other one. Okay, well, that's going to be an extra, how many, over thousands of dollars. Or you have a situation where you do not have the rights assigned to you, you do not have exclusivity, and the designer is showing off her portfolio to other restaurants. And they're like, hey, I like that medieval castle design. Could I get that? And the architect says, sure, I own the copyright to that. I can do what I want with it. And so it might be that you have a competitor who all of a sudden pops up with a restaurant that looks exactly the same because you did not get the rights assigned to you. So please, please, please be very aware and very careful of that, and make sure that you're getting that copyright assigned to you, or you're securing exclusivity in terms of the design. Now, with regard to music, just be aware that music is protectable under copyright, okay? And there are these sorts of bundle of rights that copyrights create. One of them is a prohibition against public performance without authorization. So if you are playing a song in a restaurant, that is considered a public performance. And you have the potential, it could be a situation where you're infringing the rights of the copyright owner. So the ways that you would do this, avoid infringing, is you would get a license from one of the performing rights organizations, or more of them. You might have heard of them before: BMI, ASCAP, CSAC, and there's one called GMR as well. Obviously, that can get expensive if you're trying to get them from all four of them. So, be aware. You might want to just contract with one of them in order to license songs from that performing rights organization. Okay, you can have this entire catalog or whatever, and you can play those songs in your restaurant. You could get a direct license from the copyright owner. You could play live music that's in the public domain. Okay, you could do that if you wanted to. Or, and this is probably where a lot of you are going to jump in here, is this small business exemption. Now, I will tell you right now, I am not an expert in copyright law, and I am certainly not an expert in the small business exemption. Let me just briefly read from my notes, because this might be of interest to a lot of you if you have a single restaurant. So federal copyright law exempts restaurants that play music if it is transmitted via radio, TV, and cable and satellite, so long as you're not charging to hear the music. Okay, so if the music is transmitted via radio, TV, cable, or satellite, and you're not charging somebody to listen, then you might be okay. But be aware that CDs, MP3s, DJs that you hire, live bands, that's not covered by the exemption. And internet radio, like Pandora, also not covered by the exemption. And then there are some very specific things about the size of the restaurant, smaller than 3,750 gross square feet, and things like that. So these specifics are in the speaker notes to this presentation. I'm not going to spend a whole lot of time going over them. If this is something where you're like, uh-oh, Jason, then please research the small business exemption or talk to somebody at the SBDC. They might be able to help you out to sort out if this is a situation that applies to you and you would be allowed to play, music from the radio or the TV, something like that. Okay, so the speaker notes are going to have some of the specifics, and so you can take a look at that when you get a copy of the slides. Okay, so any questions before we move on to patents?
No questions right now. Thank you, Jason.
I am hearing none. Okay. Okay, so we'll jump into patents here. As remember, we talked about patents. These are going to be protection for typically for inventions and things like that. There are actually three main types of patents: the utility, design, and plant patents. We're just going to focus on utility and design patents first. This is going to be protection for sort of like what the food looks like, and the protection here is going to run from the grant of the patent, not from the date that it was filed. So it could protect how the food itself is displayed or the shape or configuration of the food, and that protection is going to be limited to 15 years from the grant of the patent. Let me give you a couple of examples here. You might have seen this one before. This was a registered design patent by Contessa Food Products. It was a design patent for this, shrimp serving tray where the shrimp go one way and then go the other way. So this was protected by design. When you saw that, that was essentially that layout was protected by Contessa. There's also these folks who registered the design of this pretzel, right? This was a peace symbol pretzel. So that design was protected by a design patent. Both of those things are now expired design patents. But be aware that there is an overlap between the sort of design patent protection and also the trademark configuration. So if we think about our Coca-Cola bottle or a Weber grill or a Volkswagen Beetle, the shape of the thing. In terms of food, think about a Pepperidge Farms goldfish cracker or a Hershey's Kiss or a Bugles corn snack. Okay, those are all protected by trademarks because it's a registered trademark. When you see a Hershey Kiss, you automatically know who the maker of that is. And there is some overlap here with if you see the Peaceable Pretzel, you automatically know who that is. Okay, so that is design patents. There's potential of protection here. Probably it's usually not something that's a heavily used part of intellectual property, but I want you to know it's available to you. Also probably going to be fairly underutilized for folks running a restaurant or a food truck or something like that are going to be utility patents. So these are going to be protection for a new or unique way of maybe preparing a dish or something like that, or a new device that you've created in order to help you do something in the kitchen, or a new device that you've created in order to help your customers eat their food. Okay, so it might be a new way that you're preparing the dish, but just be aware that your protection is going to be limited to 20 years from the date that you filed the patent. Okay, not that it was granted. So for recipes, be aware, maybe some possible protection here, but probably not. And the reason is because it's in order to be patentable, the thing you invent needs to be new, useful, and non-obvious. And then probably the way that you combine things together is not going to have a non-obvious result. So let me say that a different way. The way that you combine something together is probably going to produce an obvious result, right? If you put more sugar into the recipe, it's going to be sweeter. You put more salt in, it's going to be saltier. So unless there's this new way of putting things together that creates something new that nobody had ever thought about before, probably not going to be something that would be patentable. And notice the protection does run for 20 years from the filing date of the patent. The other reason you might want to reconsider like using a utility patent to protect a new way of doing something is because of this limited protection. Another way you might want to think about it is through what is called a trade secret. And I'm just going to combine these pretty quickly so we can get to any additional questions at the very end. I'm almost done. So a trade secret is going to be available for information such as a recipe or your customer list or a vendor list or the way that you are making something in the kitchen. So it might be instead of letting everybody know how you make something in the kitchen by trying to get patent protection for it, you don't tell anybody, okay? And instead you keep it secret. And so the way that you keep it secret is going to have value because nobody else knows how to do it, okay? Because if other people knew how to make KFC chicken, why would you go to KFC? You're right. Or everybody knew how to make Mrs. Fields cookies. Why would you go to the mall and buy a cookie from Mrs. Fields? Okay. So the information has value because nobody else knows how to do the thing that you were doing. And it has value because nobody else can legitimately get it. They would have to sneak in and steal it from you somehow. And you have also taken efforts to maintain that secrecy. And so ways that you might want to think about that if you have some signature dish that you don't want anybody else to know how to make, don't show anyone how to make it, okay? Or don't write anything down. And you could also promote it as your unique creation. So yes, it's going to be making more work for you because you're not going to have, a sous chef helping you along there or somebody preparing things to help you. You're going to be doing it all on your own, but it also means that no one else is going to know how to make the very particular thing. And you can keep it secret so it can be something that is a specialty of your restaurant, such as this clear pumpkin pie by Chef Achatz at Alinea in Chicago. All right, so that's the basic run through. Let me hit some resources real quick, and then we can spend the rest of our time answering any questions that you might have. Lots of great resources available to you on the USPTO website. I will show you right now. This is what our website looks like. I would recommend that you go up to the top here of uspto.gov, hover over the word trademarks. That pulls up this mega menu. If you look on the left-hand side under Getting Started, select Trademark Basics, and you're going to find a lot of the information that we talked about today right here on this page. So if you're like, I never want to hear Jason talk again, I would rather read the information, Cool, I get it. You can find a lot of that information right here. And there are, just little things you can jump in and I'm like, what was a trademark again? I forget exactly what Jason was talking about. Well, obviously you can see right here, there's a nice little breakdown of what a trademark is and the difference between having a trademark, owning a trademark, things like that, and also the TM, the SM, and the R in the circle. So we have lots of great resources that are available to you on the website. And I would specifically point out the Trademark Basics Registration Toolkit down at the bottom there, that link. You can follow the www.uspto.gov/trademark basics toolkit, and that'll take you to a downloadable PDF that sort of takes you through the registration process, the things that you need to know at various steps along the way. Lots of other great free resources that are available. You can see the link there for uspto.gov/free services. There's a lot of patent related things that are there, as well as some trademark things as well. If you're interested in having some low cost, that is free legal help, we'd recommend the Law School Clinic program. These are law schools that we've partnered with around the country. There are over 60 of them at this point. And some of them, they don't care where you're located. Some care geographically. Some of them do patents, some of them do trademarks. But essentially, if you become a client of this clinic, then they will help you for free with your trademark registration. You're going to be working with a trademark attorney who may also be a professor at the law school, and also getting some assistance from some law students. So you're getting all the services for free, and of course, law students are getting to learn before they begin their career in intellectual property. If you have general trademark questions, you can always contact the Trademark Assistance Center. There are customer service folks. They're open 8:30 a.m. to 8 p.m. Monday through Friday. That is Eastern time. Give them a call, shoot them an email. They love to talk to you. They love to be able to direct you to various resources. Just be aware that they cannot provide legal advice, just like I cannot. No one at the USPTO can. We also cannot recommend an attorney to work with, but we do recommend you work with an experienced trademark attorney. You don't have to if you are domiciled here in the United States, but we do recommend it. We would say be very careful of the trademark filing companies that are out there. You do a Google search, you're going to see a bunch of these companies that are trying to advertise and try and get you for a low price. They're guaranteeing registration, which I've seen. Nobody can guarantee registration. Okay, you might have a pretty good idea that something's going to register, but nobody can actually guarantee it. We do not have any companies that we certify that we work with. There are no licensed entities that are out there that we say, oh yes, this is, we recommend using them. Nope, none of that is true. If you happen to see any of those claims out there, just be very, very careful. The only people who should be helping you with your trademark filing and registration are attorneys. So if you want legal help, if you want help with your application, even though they say, hey, we'll help you file it. Okay, all they're doing is filling out a form that you could do on your own. If you want actual help making decisions about the things that go into your application, the only person you should be talking to is an experienced trademark attorney. Now, obviously, those can be expensive. If the Law School Clinic route isn't your thing, you can check out a couple of other resources through the American Bar Association, also through the International Trademark Association. They have a pro bono clearinghouse. And of course, we always recommend our PTRCs, our Patent and Trademark Resource Centers, libraries we've partnered with around the country, and also all of the great programs that are provided through the SBA, one of which is, of course, the SBDC. So there are lots of resources that are out there. You're obviously well aware of the SBDC and all the resources that are provided through that. But we always recommend them because you can get lots of great regular business help and startup advice through these sorts of organizations. Okay, so we're to the official question part of things. I'm going to stop sharing my slides, or actually what I'll probably do is bring up this in case anybody has any questions.
So if you guys have questions, if you would put them in the chat so that we can have Jason answer them for us before he goes. Jason, I have to tell you, that was one of the best presentations I've seen in a very, very long time. You are a fantastic presenter, and I learned a lot.
Well, good. Thank you so much. I appreciate that.
So while we're giving it just another couple minutes to see if there's any additional questions, everyone who attended this presentation today will receive a recording of this presentation along with the slides. So I'm not seeing any additional questions. Just a reminder that there will be a short survey as part of the conclusion of this program. If you could please make sure to fill out that survey, that really helps us to inform training that the Arizona SBDC network brings to you and how we can support you better. And then we have in the chat from Julie to request assistance from the ASU Patent or Trademark Clinic, email trademark_clinic@asu.edu or patent_clinic@asu.edu. To request assistance from the U of A IP Clinic, email law/ipclinic@list.arizona.edu. Thank you.
And I will pull up the law school clinic information here on the.
That is a really good resource.
Slow right now, but all right, here we go. So as you can see here, there's more information about the law school clinic program. Open this up. You can see this list of participating schools, and as you can see there, ASU is the second one that is listed. So and let's see, probably U of A is probably down at the bottom.
What a great resource.
Yeah, here we go. Yeah. Here you go. And this is for folks that are in Arizona only at the University of Arizona. So be aware, these are incredibly popular programs and there are eligibility requirements, but by all means, shoot them an email, tell them your situation. You probably have to fill out a form or do whatever. But if you're going to get accepted into one of these clinic programs, it can be a really great resource for you, especially if you want to get that registration and you don't have a whole lot of money lying around to hire an attorney. This is a great way to go about getting that legal help that you might need.
Fantastic information. Well, thank you, Jason. I really appreciate it. Thank you for our attendees for joining us today. I hope you enjoyed this and learned as much as I did. And from the Arizona SBDC network, have a great day. Thank you all.
Thank you.
Bye-bye.